Welcome, everyone. Glad to have everybody here, to all the parties involved, to the public in attendance, to everyone joining us by live stream. I'm glad that we got the ability to live stream so that anyone in the world who's interested in these proceedings can watch every second if they choose so. Now, this case is a little unique. It's important for our state, and I know that the commissioners and the commission staff are very well prepared, and we're looking forward to these proceedings, and I think we're very much up to the challenge ahead. We've been given a very aggressive schedule by the General Assembly, and we're going to meet their expectations. So I want to thank our hearing officer, Mr. David Butler, for overseeing these proceedings, and for all the parties for attending the pre-hearing conference, where we laid out expectations for your cooperation to make maximum use of the time that we've all been given. Now the challenge is going to be you to meet those expectations. So I urge everyone to remember and follow the procedures that we've set, and I'll certainly be here to help you do that. One thing to say, and with that, I will say that I was a little disappointed after allowing everybody a 5-minute opening statement that some of you have worked to switch and swap up time to get a little more time. So I hope going forward, we'll do better than that. Want to remind everyone that except for these 3 mics right here, all the mics at the tables, all these mics are live. So if you need to whisper, you better turn your head because somebody might hear you. Okay. With that being said, I'm going to ask Mr. Butler to read the docket.
Yes, sir. Thank you, Mr. Chairman, members of the Commission. We're here on a combined hearing for 3 dockets today. First is docket number 2017-207-E, Friends of the Earth and Sierra Club versus South Carolina Electric and Gas. Docket number 2017-305-E, which is the request of the South Carolina Office of Regulatory Staff for rate relief to SC&G rates pursuant to Code Section 5827-920. And finally, docket number 2017-370-E, the joint application and petition of South Carolina Electric and Gas Company and Dominion Energy, Incorporated, for review and approval of a proposed business combination between SCANA Corporation and Dominion Energy, Incorporated, as may be required, and for a prudency determination regarding the abandonment of the VC Summer Units 2 and 3 project and associated customer benefits and cost recovery plans. Mr. Chairman, other members of the Commission, the docket is in order.
Thank you, Mr. Butler. Okay, now we'll take appearances, and we'll try to do this. Mr. Butler's going to make sure I stay on the right page in the right place. Friends of the Earth and Sierra Club.
Good morning, Mr. Chairman. Robert Guile of Columbia for Friends of the Earth and Sierra.
And we're going to need to make sure everybody gets close to a mic so that folks on live stream can hear you when we do these things. Office of Regulatory Staff.
Good morning, Mr. Chairman and Petition. Can you hear me?
I can hear you. Everybody else good?
Matthew
Is it?
Richardson.
No, not in the back. I'm not sure.
Sound like his own.
Yeah, it's on. Get closer.
Thank you, Mr. Chairman. Matthew Richardson and Jim Cox from the White's firm on behalf of Office of Regulatory Staff. Of course, Jeff Nelson is here, along with our director, Nanette Edwards, and several other staff.
Thank you. CMC Steel, South Carolina.
Yes, Mr. Chairman, I'm informed that CMC Steel, South Carolina, will not be participating in these proceedings, and Mr. Shishis has asked to be excused from the proceedings.
Okay, thank you, Mr. Butler. William T. Dowdy, pro se. Okay, Mr. Dowdy is here. Frank Knapp, pro se. Walmart Stores East and Sam's East Incorporated. Thank you, Stephanie. United States Department of Defense and all other federal executive agencies.
Good morning, Emily Medlin on behalf of the U.S. Department of Defense and all other federal executive agencies.
Thank you, Ms. Medlin. Lynn Teague, pro se.
Good morning.
Speaker James H. J. Lucas in the South Carolina House of Representatives.
Thank you, Mr. Chairman. Michael Anselmo and Rob Tyson here on behalf of the Speaker.
Thank you. Central Electric Power Cooperative Incorporated, the Electric Cooperatives of South Carolina Incorporated.
Good morning, Mr. Chairman, members of the Commission. Frank Ellerby, and with me is partner Kevin Bell, the Robinson Tinkin Law.
Thank you. City of Orangeburg.
Mr. Chairman, I'd understood from the City of Orangeburg that they would not be participating in the hearing.
Okay, thank you. South Carolina Coastal Conservation League and the Southern Alliance for Clean Energy.
Good morning, Mr. Chairman, Mr. Vice Chairman, members of the Commission. I'm Bland Holman, representing the Coastal Conservation League and the Southern Alliance for Clean Energy. My colleague Will Cleveland is going to be leading this case for us. We've also got Gudrun Thompson and Elizabeth Jones here on behalf.
Great, thank you.
Thank you.
AARP.
Morning.
I don't think that one's on. Thank you. South Carolina Energy Users Committee. Thank you, Mr. Elliott. South Carolina Attorney General.
Good morning. I'm Emery Smith from the Attorney General's Office, and with me is Bob.
Thank you. South Carolina Solar Business Alliance.
Mr. Chairman, I'm Richard Witt from Austin Rogers, representing the South Carolina Solar Business Alliance and Southern Current. With me are Ben Snowden and Joe Dowdy, both of Kilpatrick Townsend. They've both been admitted pro hoc vici.
Thank you. Yeah, Mr. Witt, I'm sorry, and I didn't say Southern Current, but you said it, so we got you in, so thank you. South Carolina Public Service Authority.
Chairman, I'm William Hubbard from Nelson Mullins. I'm joined by Carmen Thomas from our firm, Mike Baxley, our General Counsel at Santee Cooper and Babs Warner, Corporate Secretary.
Thank you. Dino Tapera, pro se. Okay. Transcontinental Gas Pipeline Company.
Mr. Chairman, I am aware that there was a stipulation signed with SCENG and Dominion between Transco and the joint applicants in this case, and they had asked to withdraw their testimony and said that they would have limited participation in these proceedings, as I understand it. So,
Okay. Nobody's here. That's very limited. South Carolina Electric and Gas.
Good morning, Mr. Chairman. My name is Chad Burgess. I'm in-house corporate counsel for SCNG, and with me today is Matthew Gissendanner. He's also in-house corporate counsel for SCNG. Mitchell Willoughby from the law firm of Willoughby and Hafer, and Belton Ziegler from the law firm of Womble Bond Dickinson. From the law firm of King and Spalding, we have David Balzer, John Challey, Julia Barrett, and Brandon Keel. And on behalf of our team, it's a pleasure to appear before you, and we look forward to presenting the company.
Thank you. Dominion Energy.
Good morning, Mr. Chairman, members of the Commission. I'm Joe Reed from Bar Woods Law Firm, and along with David Black, I'll also counsel from the company.
Thank you. Okay. One thing I've been told, with all these microphones, we don't want to get whipped by technology. The mics can be raised and lowered if you're seated and want to speak, but for all the microphones, please speak into them, especially when you're going to speak, because if you're not on the microphone, nobody on live stream hears you. It's just like a dead spot. and we want to make sure our court reporter gets everything. Okay, now I need to ask if there are any preliminary matters, and I want to remind the parties that the Commission's not taking oral argument at this time on any dispositive motion. So is there anything preliminary that we need to hear?
Yes, Mr. Chairman, Matthew Richardson on behalf of ORS, Office of Regulatory. We actually have 4.
Get close to that mic. That one doesn't seem to be picking up as well.
Thank you, Mr. Chairman.
That's better.
I appreciate the reminder as we go along. We have 4 preliminary matters that we'd like to take up, none of which take more than just a couple of minutes. And I'd like to address first an issue that's been plaguing this process since the beginning. The Commission and the hearing officer have already tried to deal with it. We'd like to put it to bed once and for all, and that is the confidential designations by SCNG. We moved to remove the blanket confidentiality designation by SCNG. And since then, we've notified SCNG that we don't believe any communication or document on this project should be shielded from the public, and that they should identify each specific document and claim of confidentiality because they have the burden of proving something should be kept from the public. And so we ask now to just complete the process that we've all been in, then ask that all confidential designations be rejected so that this proceeding can proceed without that concern.
Yeah, let's go ahead and get all your concerns, and then we'll get a response on that.
Sure. Second, Your Honor, we reserved in our pretrial brief a kind of general potential objection to the admission of testimony or exhibits that were not drafted by SCNG's witnesses themselves. But we'd like to waive that objection now as to admissibility, and we'll just cross-examine their witnesses about that because we believe it should be taken into account as to the credibility and the weight of their testimony, and it's not an admissibility objection. Third, Your Honor, there's several high-level SCNG officers and a senior engineer who appear to be relying in their deposition testimony on advice of counsel defense about witness testimony in front of this commission in 2015, specifically the 2015 modification of the schedule and budget. And, Your Honor, I think it's only fair that we say up front that if that persists, if that continues to be the reason why the testimony was changed, we'll have no option but to ask that that the privilege with those attorneys be waived or is waived by that defense, and that we proceed and move to amend to add those attorneys as witnesses in this matter so that we get a full hearing of those issues. And unfortunately, some of those are counsel of record in this proceeding, and so that's why we're raising this now as a preliminary matter, and just so that that they're all aware. Obviously, we're not making any motion or any amendment at this time, but because this has clearly been an issue and is an issue, and now is in the record as an issue, we thought we should tell the commission that up front. The fourth preliminary matter, Your Honor, deals with the objections to exhibits. And again, this is important to us to deal with up front. In the pretrial briefs, you asked for objections to exhibits. ORS has no objections to any of the exhibits or testimony. We think all of this should be provided to the commission for the commission to decide what's important, what's relevant, what matters to the decision. But SCNG provided us with 100 pages of objections, some of which this morning and late last night we were informed may be waived, Your Honor. But some background may be helpful. We are taking the position, and we feel strongly about this, that none of these objections to the exhibits that are being offered are in good faith, and that they should all be completely rejected right now. And we say that so that we can all proceed expeditiously and without the unnecessary formalities, in particular of testimony from records custodians. We have, and you all have, the certification in the notebooks you got this morning, tab 3, of the corporate secretary of Santee Cooper. She is the proper record custodian, and that certification should satisfy all concerns about the authenticity and the reliability of all of the Santee Cooper documents. You know, Hearing Officer Butler very wisely instructed all of us to submit as much testimony as possible in written format. And we think that those contemporaneously created records that are public records of a public agency and that are business records of a business that have now been certified by their records custodian are the best evidence of those that were working and communicating on the project. But more than that, Santee Cooper is not just some public agency or just some business. It's the partner for which SC&G was the agent on this project. And that's why the objections should be completely rejected at this point. You know, don't want to go into the history, but just suffice it to say that until 6 o'clock last night, there was over 100 pages of objections. Now they say there are 10. None of them are warranted. Most importantly, you know, there's legal arguments I think that you all should be aware of, that I'm sure you are. The administrative agency need not adhere to strict rules of evidence when acting in judicial capacity. That's City of Spartanburg versus Paris, 251, South Carolina 187. And then it's just the rules of evidence themselves. There's 5 bases that mentioned that why all of these Santee Cooper records should come in, just briefly. Public records, 803.8. Business records, 803.6. They're not hearsay, and they're admissible. Once they've been self-authenticated under 902.4, which is a certification from the corporate secretary, they're reliable, and they've been authenticated. And now, finally, it's the question of why are they being used? We're not here to put the specific actions on trial, what happened. It's a prudency determination for which largely depends on what they knew at the time, and that's notice. And under the notice provisions, the use does not implicate hearsay. And last, we think it's important to note that one of our early witnesses, and why this is important now, is Mr. Gary Jones, and you're going to hear from him because he's an expert, construction expert. And these are the types of records that happened during the proceeding, during the project with the SC&G that would be relied on by an expert, by a construction expert, and that's reasonably relied on an expert. They're the types of records that you have to go and look at and rely on. And that's why we believe that this is something that should be dealt with up front and now, and present this issue right now. And you've heard our arguments about the law, but in any event, all of these documents have been identified, provided in discovery. They are authenticated now. They've been basis for admission has been provided. The corporate secretary's certification is there. If necessary, she will come and testify about every document. And if further than that is necessary, we'll call every person at Santee Cooper needed to get these records in, because they're part of the project, they're part of the record, and in particular the connection that as a junior partner and as the agent of Santee Cooper in this project, these are reliable records that were created and maintained in that regular course of business and as their public duty in this project. And so from our perspective, and we think that should be from the Commission's perspective, these documents are authentic, they are reliable, and to the extent that they need to be questioned, put in context, or explained, every single witness available to us is at least as available to SC&G to provide this Commission with more information and not less. Thank you all very much.
Thank you, Mr. Richardson. I'll take a response from South Carolina Electric and Gas.
Thank you, Mr. Chairman. Our first point would be that these objections are properly raised at the time that the witness is answering the objection. These objections are properly raised at the time that the witness sponsoring the exhibits is on the stand and can be examined as to the witness's knowledge of how the exhibits were prepared, what they suggest, what they say, what constitutes an impermissible opinion evidence within the specific exhibit, and the other indicia of an exception to the hearsay rule. The rules are very clear. Under Mr. Richardson's approach, any document that could be found anywhere in Santee Cooper is admissible for any purpose in this proceeding, and that's not the law. The business records exception is very limited. None of the exhibits that we are objecting to fall within the business records exception because they have to be routinely kept records that are contemporaneous, that do not include opinion, and that are based purely on people who were involved with the business in handling the particular matter in question. So those standards have to be looked at and applied to each of the 10 exhibits that are at issue here. In addition, the business records rule is intended to allow in documents where there is an opinion, where there's not something that the other party will need to respond to by examining the person giving the opinion, the person involved in preparing the document. SC&G, under the proposal that's been made by ORS, would have to find a way to determine who wrote the documents. Many of these documents that were provided to us were not given any attribution, and that's one of the reasons we objected to them. And we would have no witness that we could examine as to what the context of the document was, how it was produced, whether that person used the document for the purpose that it apparently was used for, whether the person changed their mind after they talked with others about what's said in the document. We're simply expected to take on face value every written word that's in these documents. They do not qualify under the business records rules. They do not qualify as an admission by a party opponent. But the point is, those issues need to be resolved when we have a witness on the stand and the documents in front of us. They're not appropriate for resolving wholesale at this point. As to the confidential designations, what SC&G's position has been is that if ORS can point to the things that they want released, we will be happy to discuss that with them, to release the confidential designation. There is material that is confidential for business reasons. SC&G is a SEC-regulated company. There's certain information that we have to be careful about, the company has to be careful about because of its market value or its confidential value, its commercial value. There's information that is attorney-client privileged. There is an attorney-client privilege, and it does apply, and we need to be able to deal specifically with the things that are relevant to particular passages of documents that ORS wants to release. So we've asked them to tell us, and we'll have that dialogue, but they say instead either release it all or release nothing, and we don't think that's appropriate. They need to tell us what they want us to spend time looking at. We'll look at it with them. We'll discuss it here at the hearing if we have to, but that is our position. I'm going to let Mr. Burgess respond on the council issues, since that is a matter that, I'm sorry, Mr. Balzer.
Good morning. I'm David Balser, King and Spalding. With respect to Mr. Richardson's statements about the attorney-client privilege as it relates to communications between counsel of record and witnesses, as I understand it, no specific request is being made now by the ORS with respect to those communications. So I don't believe there's anything that the Commission needs to do this morning. I would note that we've been in dialogue and discussion with the ORS and its counsel over the past several days. None of these issues was raised with us until this morning. It's the first we've heard that these issues were going to be taken up. These issues were not raised in the pre-hearing brief. So I think we should wait and see what the testimony indicates, and then at the appropriate time, if the ORS seeks a ruling from this commission that the attorney-client privilege should be waived, we can take up that issue then and perhaps present some briefing on that, because of course the attorney-client privilege is one of the most important safeguards in our legal system, and that is not a privilege that should be lightly disregarded. So we will be prepared with briefing if necessary to address whatever issue as it comes up. As I understand Mr. Richardson's comments, nothing need be done this morning with respect to that issue.
Mr. Richardson, you're right.
Mr. Chairman, thank you. I can just agree with Mr. Balzer. We've not subpoenaed nor moved for any action on the issue. I thought it was only fair to raise that point. The confidentiality issue is easily addressed because the burden's on them. And we've been saying repeatedly, and this commission has issued orders about it as well, that there should not be a confidentiality. That should be the default, no confidentiality, and the burden certainly shouldn't be shifted to us. We've said that we don't think any of it with an abandoned project should be withheld from the public. On the rules of evidence, obviously we feel strongly about this, disagree about the strict application of rules of evidence, but we've complied with them actually in this case. The issue about opinions and investigative reports, Santee Cooper's done nothing about investigative reports. That's not applicable here. And all of these Santee Cooper documents, we just confirmed, all of these Santee Cooper documents are covered by the corporate secretary's certification. And there is no requirement of a sponsoring witness for certified public records. And that gives you a clear path to avoid unnecessary testimony, additional testimony to the certification, and allow this hearing to proceed with all the public records in this case and about this project being available to the commission. Thank you.
Okay, we're going to hold a ruling on all of these issues in abeyance right now, and then we will let you know about what we decide on this. Okay. Any other preliminary matters that we need to?
Mr. Chairman, I rise for the sole purpose to inquire about when it would be appropriate to introduce into the record the settlement agreement between Transco and SCE&G and Dominion Energy. Historically, that's been a preliminary matter that has been addressed with this commission. So if now's the appropriate time to introduce that into the record, I will be happy to do so.
Okay, we'll do that.
Mr. Chairman, we would move into the record as the next hearing exhibit. I'm sorry, I don't know which number we're on.
We'll number it.
Thank you. The settlement agreement that was executed between Transco and Dominion and SCE&G.
We're going to use the microphone. We need for everybody to please not shout out in the courtroom. Please don't talk out loud. Ask somebody back there. The Transco and SCE&G and Dominion agreement will be entered into the record as exhibit number 9. Everybody make sure you pick up the mic and put it close. Okay. Okay, now we're ready for, we're allowing an opening statement from everyone. Please stay within your limits. And we'll start with Friends of the Earth and Sierra Club.
Thank you, Mr. Chairman.
Yeah, look for that red light.
Good morning, Mr. Chairman, members of the Commission. I'm Robert Guild of Columbia. I'm appearing this morning on behalf of Friends of the Earth and the Sierra Club. Both my clients have members who are ratepayers of South Carolina Electric and Gas, Santee Cooper, or the electric co-ops of South Carolina, customers who would be served by the canceled, abandoned VC Summer Units 2 and 3. Sierra Club is the largest nonprofit grassroots environmental organization in the country, over 700,000 members, 5,000 in South Carolina, and 7 local groups. Friends of the Earth is affiliated with the international organization, Friends of the Earth International, the largest environmental advocacy network in the world, and with representatives in over 70 countries. We have participated in each of the Commission's proceedings involving this project since its inception in 2008. Our objectives in this consolidated proceeding are, first, to protect ratepayers from unjust and unreasonable electric rates stemming from SCE&G's imprudently incurred investment in the failed nuclear project. And second, to pave the way for an affordable and clean renewable energy future for South Carolina. These are the same interests we've had and sought for the last 10 years since our initial challenge to the original baseload application, as imprudent compared to available, less costly alternatives. The way we see it, Mr. Chairman and Commissioners, it's as if we're confronted by a murder followed by an armed robbery. We find ourselves at the scene of the crime, a smoking gun in SCE&G's hand, standing over the dead body of the abandoned VC Summer nuclear project. And SCE&G, holding that smoking gun in its hand, says, "Who, me?" After denying all guilt for the murder, SCE&G turns the gun on us, the ratepayers, and you, the regulators, ORS and the Public Service Commission. This is a stick-up. Give me your wallets. Or what? I'll shoot. I'll shoot myself. I'll declare corporate suicide. I'll declare bankruptcy. The Greeks have a term for this behavior, hubris, excessive pride leading to one's downfall. And hubris is the theme of this tragic case. The Baseload Review Act was a sweetheart deal. It provided for early cost recovery so long as you stuck to the bargain. You built a plant on budget and on schedule, and the costs could be recovered early from ratepayers. But that deal was just not good enough for SCE&G. They had to lie and distort in their initial prudence demonstration, and then withhold material facts about the imprudence of the project over the last 10 years. A variety of alternative theories all lead to the same ratepayer relief. The BLRA may well be declared unconstitutional as applied because it allows recovery for non-used and useful utility plant. May be declared unconstitutional because it denied due process to ratepayers all these last 10 years. It may be denied because it's determined that SCE&G committed fraud as defined by the Baseload Review Act, which is equivalent to imprudence, the failure of the duty to disclose material facts to the regulators, or outright dishonesty in the reporting of the cost and schedule of the project as it went forward. Finally, it may be determined ratepayers may be protected because the BLRA bargain has been lost by SCE&G since the project is not being constructed per an approved Baseload Review Act order under 5833-275 A and C. And last, I should say, just basically the question of those imprudent costs, because the company now bears the burden upon abandonment of demonstrating that, considering the information available at the time, that the utility could and should have avoided these costs under 5833-280K. This is a story of greed and deception from the very beginning. The deeper they got into the imprudent project, the greater the deception. You'll hear testimony from our witness, Dr. Mark Cooper, and other interveners in this case, will demonstrate that not only was the project imprudent to begin with, imprudent in 2012 when Dr. Cooper last talked to you and urged you to pull the plug when only $1 billion is on the table, not the money that's there now, and that the project became increasingly imprudent as time went by. We could have turned a $10 billion bet initially into a $24 billion nightmare had they proceeded with completion of construction. But at least they pulled the plug at this point and not at a $30 billion plant, which is where the companion Bogle project appears to be heading today. I want to say that once we got to the point of abandonment, we have to ask ourselves, where are those persons who were responsible for this imprudent process of decision-making? Where's Mr. Timmerman? Where's Mr. Kevin Marsh? Where's Mr. Steve Byrne? Well, they have their platinum parachutes and cushy retirements. They're no longer with us to defend the course of conduct in this process. But then we have Dominion, the white knight that's here out of good faith to protect the poor, imperiled ratepayers of South Carolina? Or are they indeed, alternatively, the black vulture that's merely feeding on the wounded beast, the carrion of a dying SCENG? We urge this commission to reject all claims to recover abandoned project costs as imprudently incurred. And in addition, we ask you to closely scrutinize the proposed Dominion takeover of our electric service franchise. We ask you to ask this question: is Dominion the best candidate to serve South Carolina's energy needs into a clean and affordable energy future? Thank you, Mr. Chairman.
Thank you, Mr. Guile. Office of Regulatory Staff.
Thank you very much, Mr. Chairman. Commission. The other night I tried to explain this case to my little girl who's in the third grade, and she asked me a simple question. She said, why would they make us pay anything, any money, if we don't get anything? And it's a little hard to explain that, but what's even harder to explain is why the SCANA shareholders should get a profit out of this, and why the executives should get their bonuses paid by ratepayers. But that's exactly what SCNG is asking the Commission to approve: more profits and more bonuses now for a failed project. But it wasn't just a failed project. It was the fraudulent acts that I'm going to talk about in 2015 that needlessly cost us billions of dollars. We're not here for punishment. We know that. We're here asking for a permanent electric rate that is just and reasonable, considering the burdens on the ratepayers who have already paid $2 billion to finance a project and who are facing, who will not get any energy generation from the $5 billion more spent to construct. In any construction project, there's a critical path. It's the sequence of events with the shortest possible time to completion. SCNG, we know, didn't focus on that as the project's owner, but we'll need to do that for this case. You've seen piles of pre-filed testimony and exhibits, and you'll hear a lot of issues that aren't on the critical path of this case. We know because SCNG ran to federal court this summer, complaining of certain and permanent damage because of the experimental rate. None of those threatened harms have occurred, and doomsday didn't arrive. But some of those same characters are going to show up here in this hearing and rattle their sabers and gnash their teeth. But we know better, and now we know more. In late 2015, SCNG knew it needed modification of the construction schedule and costs that had been approved by the Commission in 2012. There have been significant delays and substantial cost increases, and the consortium had provided in August of 2014 an estimate at completion of the cost, and that was being reviewed internally by SCNG. Those disputes with the consortium had come to a head in 2013, but they still weren't resolved in 2014. And SCNG should have and could have paused right then, at least in early 2015. And its own internal review of those estimated costs told senior management that the consortium's budget and schedule were way too optimistic and were wrong in early 2015. Instead, senior management and SCNG's outside attorneys overruled those witnesses who did the analysis, changed the story, that was told to this commission, beginning on March 12, 2015. In April 2015, the Santee Coopers Point people on the project gave them charts showing a clear trend to completion was years later, if not decades later, beyond what was being requested in the modification. And that was ignored too. And so before this hearing and the approved budget and schedule, the top management at SCNG learned that the shield building was going to be even further delayed. This is in later 2015. But they ignored that. Instead, they provided testimony to the commission that what they were requesting was the best information available. In April 2015, the same time period, right after the petition, SCNG agreed to hire one of the world's largest and most experienced nuclear power plant construction engineering firms, Bechtel Power Corporation, to perform a comprehensive assessment of the project, including a scheduled assessment at the cost of $1 million. And that assessment confirmed what SCNG already knew about the substantial delays and the increasing costs in late 2014 and early 2015. And it provided the accurate substantial completion dates then. That report was reported to SCNG in October of 2015. They buried it. They refused to share it. They lied to ORS about it and in the document request before this commission. They've denied it even existed. They convinced Santee Cooper to flush the report. They fought against this relief after abandonment and after waiving the privilege in a filing with this commission on June 11, 2018. And they fought for it to remain confidential even now. The report gave SCNG another option, though, other than failure. But they didn't take responsibility for the project to be actively managed. In fact, they refused to get an owner's engineer to oversee the construction, something they were permitted in the original EPC contract, and which they had been repeatedly advised and encouraged by their partner, and which was recommended by Bechtel as part of its 2015 comprehensive assessment. SCNG just didn't come clean about the true schedule and cost because not meeting the guaranteed substantial completion dates and losing the $2 billion in production tax credits would take the project out of the money. It would have been obvious to everybody at that point. And it would have stopped the approval of revised rates. It was just a month after Kevin Marsh's testimony to this commission in 2015 to modify the schedule that Bechtel confirmed the productivity factors forecasted monthly completion percentages that were used by SCNG. It confirmed that they were unrealistic and had never been achieved in a nuclear power plant construction ever. But SCNG already knew that. Slide 1. I'm just going to show you 2 slides, but slide 1. This shows the productivity factors indicated as PF, a strong indicator of efficiency in completing the project and controlling labor costs. And on July 21, 2015, at the commission hearing, SCNG's senior management testified that the best cost estimate for this project was based on a productivity factor of 1.15. It's the orange line at the bottom. That's what they said was the best estimate they had for the project. And the consortium had promised them a year earlier. But since that promise, the production, and in 2014, in that time before the testimony, the productivity factor had steadily gotten worse and in times was almost 3. Almost 3. Meaning it would take almost 3 times as long to complete the work. SCNG never told the commission or ORS that it knew the commission had failed on its promise in the 6 months since that promise, nor did it tell the commission that internally it had projected another $500 million in costs, greater than what it was asking. And that was due to a likely production factor of 1.55. You can see that at the slight gray line across there. But just 9 weeks later, when it was negotiating with the consortium to protect its own profits and bonuses in the EPC contract amendment, it used a best-case scenario, from their perspective, of 1.75. Clearly, they didn't believe at the time what they were telling ORS and the commission, and it meant that they knew the project couldn't be completed within the approved dates or the approved schedule. And they knew, and SCNG knew, that what they were testifying as the best information available to them was not true. Now, we know how easy modifications to a schedule are under the BLRA, and so only open and honest transparency would have checked the strong economic incentives to continue spending money on a project that the actual knowledge of SCNG in 2015 should have caused them to stop and complete an honest assessment before deciding to continue under accurate disclosures and forecasts. That was finally done in 2017. They knew what to do. They finally did it in 2017, but it clearly should have been in 2015. You all know the rules. They bear the burden of proving by preponderance of evidence. The problem was that its decision in 2015 not to abandon, they have the burden to prove that was prudent, and it wasn't. We know it was imprudent. It was untimely, and that violates the rules of what SCNG has to follow in recovery in this case. We think the evidence of SCNG's violating these rules is clear. So let's look at the last slide. This is the big picture of setting the abandonment, the permanent rate. Top line's black line is full revised rates. That's $147.70. The red line is the joint applicant's customer benefit plan. Other than the upfront payment, you see it spikes down in 1 year. That requires monthly payments of around $138 and then trailing down for 20 years. The next line down is darker yellow is the SCNG no merger benefits plan. That extends out 50 years. If you go all the way to 2039, you see it's still going for another 30 years and has the next highest monthly bills. The next line down is the brown line. That's the alternative customer benefits plan filed just last week. That's for 20 years, and it comes close to that experimental rate, which is the blue line, which is $125.34. That's what customers are paying until the permanent rate is set by this commission. Now, the yellow line represents the base rate with no new nuclear costs. That's about $121 after the Tax Cut Jobs Act, the tax benefits that are out there. And then you've got green. That is the Office of Regulatory Staff's optimal plan with all the tax benefits that the ratepayer should get, but no merger savings. And that requires just $118.98 for an average monthly bill for a typical customer using 1,000 kilowatt hours. Ultimately, we ask you to remember the critical path in this case. Adopt the ORS recommendations and set a just and reasonable electric rate of $118.98 for the typical customer based on all the evidence that's been submitted and that you'll hear in this hearing. Thank you all very much.
Thank you. Mr. Dowdy.
Thank you, Mr. Chairman and Commissioners. My name is William Dowdy, and I have been a customer of SCENG since 2003. I have endured the entire VC Summer nuclear project. I can honestly say that it has been less than a positive experience. I am not an attorney, but it is very apparent to me that there is something very wrong with the way that the VC Summer nuclear project was handled. In my pre-hearing brief, I gave a very obvious example of a material misstatement by SCENG. In their 2016 settlement, which they entered into with various parties, including the Office of Regulatory Staff, they gave guaranteed substantial completion dates of August 2019 and August 2020 for Units 2 and 3, respectively. Remember that at this point, SCENG had already received the Bechtel report and knew that construction was progressing at a rate of only about 0.5% per month. As of August 2015, Bechtel observed that construction was only 21% complete. These completion dates were utter fiction, designed to make it look like SCENG was going to meet the deadline for the expiration of the federal nuclear production tax credit. SCENG did not know how to fabricate nuclear reactors, but they certainly knew how to fabricate numbers and dates. When SCENG abandoned the project in July of 2017, they were at most 40% complete, according to a letter that they sent to the U.S. Nuclear Regulatory Commission in December of 2017, when they asked for their combined license to be withdrawn. The problems with the project had certainly not been resolved at this point. SCENG is a reality-challenged company that is suffering from an acute case of truth deprivation. This company continues to live in a realm of fantasy. They have chosen now to focus on what the Office of Regulatory Staff knew and when they knew it. That is not the question and never was the question. The fact is that SCE&G knowingly submitted false information to the public and to this commission. That false information led to higher rates for SCE&G's customers. SCANA and SCE&G are now the subject of numerous well-deserved lawsuits and investigations. I do not believe that they can survive in their present form, nor is that desirable for me as a customer. For this reason, I am not opposed to a business combination between SCANA and another company if that combination brings a fair resolution of these issues for SCE&G's customers. However, Dominion's original, what's been called a payday loan offer, is completely unacceptable. It seeks to recognize that SCE&G's customers have been harmed, but then continues to harm them for the next 20 years. Dominion, in advertising this $1,000 cashback offer, says, that's a lot of groceries. No, that's a lot of baloney. While I welcome the effort by Dominion Energy to improve their offer by presenting their alternative plan, which offers a substantial rate reduction in lieu of a payday loan, it must be remembered that SCE&G's customers have already paid at least $2 billion to finance this debacle. A fair ruling or settlement must recognize the harm that has been done to SCE&G's customers and seek to mitigate that harm to the maximum extent possible. Of course, an ideal outcome of these proceedings would be the complete removal of the VC summer nuclear surcharge from our electric bills. However, if the Commission finds that that is not entirely possible, there are still creative options for negating the impact of the nuclear surcharge. Number one is a substantial rate cut similar to that in Act 258. Dominion Energy has actually had a dose of reality and has proposed something very similar. Number two, an expansion of the community solar program or similar programs that would allow households to receive bill credits for renewable energy generation on the order of 3 to 5% of their electric charges. This item plus the significant rate cut would effectively cancel out the portion of a participating customer's bill going to pay for the VC summer nuclear project. SCE&G already has a community solar program in which I myself participate, but this program is full and there is a waiting list. Expansion of this program could be especially beneficial for low-income households and customers who remain in SCE&G's service territory long-term. Number three, an expansion of SCE&G's residential energy efficiency incentives that provide rebates for energy-efficient appliances and efficiency upgrades. I believe that a combination of these options and other options that may be presented by other parties as well may be able to more than cancel out the effects of the VC summer nuclear project over the next 20 years. This concludes my opening remarks. Thank you for the opportunity to present my views before the Commission.
Thank you.
Mr. Chairman, I would ask leave for the remainder of the hearings after today due to my regular work obligations.
Granted. Thank you. Mr. Knapp, Mr. Frank Knapp.
Good morning, Mr. Chairman, Commissioners, Mr. Butler. I am Frank Knapp, appearing before you today as a pro se intervener. Thank you again for affording me the opportunity to be a part of this important hearing. The day that SCE&G announced that it was abandoning the nuclear project, I told the media that my goal was a complete rollback of all rate hikes under the Baseload Review Act, about 18%. In addition, I wanted all the money ratepayers had paid under the Baseload Review Act, now about $2 billion, to be clawed back. And these were the goals before we learned of all the deception that went into convincing the Public Service Commission to continue approving additional construction costs and scheduled delays. Here we are about 15 months later. These are still my goals. But I wasn't just speaking for myself back then or now. Over the many months since the official abandonment of the nuclear plants, everyday ratepayers and small business owners have made it clear to me that my goals were also their goals. The elimination of all the rate hikes and the return of all the money associated with this failed nuclear project. For the ratepayers, the extra money they have been paying over the years came with a promise. SCE&G would be good stewards of their investment, make prudent management decisions, be efficient in the construction process, and complete the nuclear plants that would provide abundant future energy at a somewhat fixed price. Oh, and coal plants could be retired in favor of a technology that would reduce carbon pollution. Instead, they got none of this promise. What they got were 9 rate hikes for the nuclear project, adding up to an 18% increase in their electric bills. And this has been on top of the 13% rate hikes since 2008. Every dollar that SC&G customers sent to the utility for this project was a dollar they didn't have to pay for their necessities: housing, food, clothes, healthcare, school supplies, transportation, to say nothing of all the frivolous spending like eating out or entertainment. All those extra dollars that the customers were sending to SC&G were also dollars not circulating in our local economies. They weren't creating consumer demand for goods and services of small businesses that often struggle with a tiny profit margin. And speaking of businesses, any other business that took a customer's money and failed to deliver the product would give the money back, no questions asked, and with an apology. That's not what's being offered by these utilities. Despite the deception and poor management that resulted in us being here today, the customer is told we can't be made whole because to do so would cause SCE&G to file for Chapter 11, or that offer from Dominion to acquire SCANA would be withdrawn. Well, I certainly am not an expert on this, but none of the New York financial advisors or others steeped in utility matters that I have talked with subscribe to this bankruptcy scenario. As for Dominion trying to set the rules for them to be the salvation for SCE&G and their customers, this commission sets the rules and shouldn't be bullied by an out-of-state mega utility, in my opinion, shouldn't even be a part of these abandonment proceedings. I will end by saying how much I and the public appreciate the hard work of the Office of Regulatory Staff. Its new mission is to represent the public's interest only, and they have and are doing so impressively. Thank you very much.
Thank you. Walmart stores.
Hello, Commissioners. Can you hear me?
Yes, ma'am.
Hello, Commissioners. We want to thank all of you for your time, and especially all of the efforts David Butler has made in making this possible. At this time, we do not have an opening statement. Thank you.
Thank you, ma'am. United States Department of Defense.
Good morning, Chairman and Commissioners. I am Emily Medlin on behalf of the United States Department of Defense and all other federal executive agencies. My clients include, obviously, Fort Jackson and other federal customers within SCE&G's territory. Opening statement will be very brief. DOD FEA has not taken a position as to whether the commission should approve or reject the merger. However, we're basically here to address certain provisions in the customer benefit plan should the commission approve the merger. The first is the $1.3 billion rate credit that the joint applicants have proposed. As it stands now, this is to be distributed via a check. And not allowing the customer to have an option to have that as a credit on the bill severely disadvantages my clients, because if they receive anything as a check, they have to return it over to the U.S. Treasury. So Fort Jackson, other federal customers within SCE&G's territory would not receive the benefit of that. So allowing, if the joint applicants would allow the customer to choose whether to receive it as a check or a credit, would allow that, or ensure that all ratepayers are given this benefit. The second issue that we have with the customer benefit plan is that the current federal tax income rate of 21% is not being used. Instead, I think a new nuclear development tax rider instead is being proposed. And then we obviously have, for the whole time, have been thinking really the better way really should not be even to amortize the $3.3 billion of the new nuclear development costs, but instead that this should be recovered through securitization. We recognize that that's not the current law in the state of South Carolina, but should the General Assembly approve and enact such legislation, then the joint applicants should allow for securitizations of these costs. Thank you very much. That concludes my opening statement.
Thank you. Okay, Ms. Teague, I think you agreed to give your time to ORS, which has been used. So we'll go to Speaker James H. J. Lucas and South Carolina House of Representatives.
Thank you, Mr. Chairman, members of the Commission. The way the Speaker sees this, there remains a lot of uncertainty in this proceeding. It's uncertainty as to how the final rate will be set, what the final rate will be, the long-term impacts of that final rate. Will we have further court challenges? Will there be bankruptcy? And the Speaker understands this uncertainty because we wrestled with it at the House for several months as we went through our ratepayer protection committees and our review. Nobody wanted to have anyone pay for a project in which they'll never receive a benefit. But the fact of the matter is you also can't set a rate that offers illusory or unobtainable relief for ratepayers. So what the House endeavored to do and the Senate agreed with was to provide a rate that provided actual relief, certainty for ratepayers, and would survive legal challenge. We cut the rate from 18% to 3.1% back in July. It was implemented in August. And our certainty that we tried to gain was confirmed by the federal court. SCENG challenged the constitutionality of the experimental rate, requested the court strike the rate and keep it from being implemented. The court categorically rejected all their arguments, found the rate to be constitutional, left the rate in place. No other rate that's being proposed today has survived such a challenge and is found to have certain relief. Now, you might hear from SCNG or others that you can't consider what happened in the federal court because it remains on appeal. It does remain on appeal. But you won't hear this, and you need to hear it now. ENG asked for relief from the Fourth Circuit Court of Appeals to stop the rate pending a decision by this commission and a resolution of the appeal by the Fourth Circuit. The Fourth Circuit rejected that argument because they weren't likely to prevail on their claims. It shows you what the Fourth Circuit thinks of their chances of success to eliminate the experimental rate. And ORS also alluded to this as well. SCNG appeared in federal court with the same three experts that you're going to hear here, Mr. Hubbard, Mr. Hebert, and Ms. Lapson. We're going to tell you of the immediate financial harm that was going to be suffered by the implementation of the experimental rate if it was implemented in August. None of that has come to pass. Yet they're going to present the same experts to you and make the same claims of financial harm. Don't be distracted. We know that SCANA and SCNG can handle the level of the experimental rate because they're handling the level of the experimental rate. Another important factor for certainty were the definitions provided by the House and Senate in their pieces of legislation that define for the first time prudency and imprudency. That's perfectly permissible, as you'll see in our response to the declaratory judgment rulings, to do so at this stage of a proceeding. The U.S. Supreme Court has said it twice in the Rivers and the Landgraf case. Our Supreme Court said it in a case that I lost at our Supreme Court, unfortunately, Harleyville Mutual versus State. Our federal court found the same thing in the case in July. The definitions are proper to be applied here and should be applied here, and will help provide the certainty that the ratepayers need. So as I open talking about uncertainty, what we know is certain at this point is that the level of the experimental rate has survived a constitutional challenge. SCNG can withstand implementation of that rate and continue to exist and provide reliable energy to our ratepayers, and that the definitions of prudency and imprudence should be applied at this hearing as the abandonment decision goes forward. So the Speaker believes now is the time to allow certainty for our ratepayers and ask the Commission to consider the experimental rate as a final rate if needed. Thank you.
Thank you. Okay, Central Electric Power Cooperative and the Electric Cooperatives of South Carolina.
Thank you, Mr. Chairman. Frank Ellerby and members of the Commission. Frank Ellerby for Central Electric Cooperative and the Electric Cooperatives of South Carolina. We're here, Central and the co-ops provide electricity. Central has a contract and provides electricity to 20 cooperatives across the state of South Carolina. On behalf of those cooperatives, Central has entered into a contract. Contract's been in place for decades, generations, with Santee Cooper. It's called a coordination agreement. And under that contract, Central and its members, the 20 distribution cooperatives, pay 70% of the capital costs of Santee Cooper. That includes, as of today, 70% of the costs of Santee Cooper's 45% share of the VC Summer project. Those 20 distribution cooperatives serve 1.5 million people in South Carolina. So that's 1.5 million co-op customers that are on the hook for 70% of Santee Cooper's 45% share of the summer project. We have estimated, folks at Central who audit and oversee the rates and work with the coordination agreement every day, they have estimated what those customers, those 1.5 million customers, will pay over the next 38 years to pay in rates what Santee Cooper wants Central and its members to pay for the abandoned project. That number is $6.4 billion is our best estimate. So we believe that the co-ops have, even though the co-ops don't get their power from SCE&G, the co-ops have a very substantial interest. Its members have an enormous interest in the outcome of this proceeding and what this commission determines on some of the issues before you. We're not here to participate with respect to many of the issues before you. The issue that we're interested in is your determination of the conduct of the owners of the project regarding whether it was prudent to continue the project. We are doing what we can to eliminate or reduce the amount that those 1.5 million customers will have to pay. That's the goal of Central and the Electric Cooperatives of South Carolina, the statewide organizations, is to try to do in whatever forums, and y'all know we are litigating we were sued as a defendant in class action. We've asserted cross claims in that class action, and we're doing what we can to reduce or eliminate the amount that 1.5 million group of customers will have to pay for the abandoned facility. And that's the reason for our participation here. We support the ORS position that was described to you by Mr. Richardson regarding the abandonment. We believe that within the provisions of the Base Load Review Act, this commission, as finders of fact, can determine that as of 2014 or 2015, the project was not being constructed within the parameters of the schedule and the cost approved by this commission. And under the provisions of 280K and 275A, because if you make that finding, and we think there is ample, substantial evidence in the record that will allow you to draw that conclusion and make that finding, and if you do, then the prudency determination that had previously been made no longer protects the spending that took place after the date on which you make that finding. That's the approach that the ORS has taken. We think that's a reasonable approach, and we think if you review the evidence, you will be able to, again, as finders of fact and as people who were familiar with what y'all were told during the progress of the project, you will be able to determine that it wasn't prudent for them to continue, and that therefore you can make a determination to exclude a substantial amount of the cost that's been spent on the project. We thank you for the opportunity to participate, and we look forward to representing the interests of the co-op members across the state. Thank you.
Thank you. Okay, we're going to take a 10-minute break. We'll be back. My watch says 11:11, so we'll be back in 10 minutes.
We're going to be here a long time.
What I realized is
Please be seated, everybody. And we'll start. One of our challenges in this building is available facilities, as they say. So there is upstairs, just in case. Okay, South Carolina Coastal Conservation League and Southern Alliance for Clean Energy.
Good morning. May it please the Commission. My name is Will Cleveland from the Southern Environmental Law Center, representing the South Carolina Coastal Conservation League and the Southern Alliance for Clean Energy. We all know this is a landmark case, but it's a landmark case for two different reasons. The first issue, of course, is how much customers must pay for this abandoned nuclear project. No one disputes the significance of that, and we, in fact, will be submitting the testimony of two different witnesses offering recommendations to how to lower customer costs for that project. But that's not the issue I want to talk about today. BC Summer and the costs related to it are the past. I want to talk about the future. Because the other half of this case is the proposed merger between SCANA and Dominion Energy. And more specifically, the manner in which that utility in South Carolina will operate moving forward. This commission has no duty to look out for holding company shareholders. If the merger is not in the customer's best interests, the commission should either deny the merger or impose new conditions on that merger to make the merger in the customer's best interests. To that end, we will present the testimony of three witnesses. First, we will present Ron Benz, former chairman of the Colorado Public Utilities Commission, who has decades of experience with utility planning. He will testify that the merger, as currently proposed, does not adequately achieve South Carolina's stated energy policy priorities, nor does it provide adequate ratepayer protections against imprudent utility spending in the future. Mr. Benz will testify that under South Carolina Code Section 48-52-210, it is the state's energy policy to, quote, have a comprehensive state energy plan that maximizes to the extent practical environmental quality and energy conservation and efficiency, and minimizes the cost of energy throughout the state. Mr. Benz will testify that the merger does not, as currently proposed, achieve these policy goals, and he will testify that to bring the merger in alignment with those goals, the Commission should require SCE&G in the future to conduct an open, transparent solicitation for new energy resources, both supply side and demand side. SCE&G should be required as part of this merger to issue a detailed request for proposal approved by this commission as to its content and form that offers renewable energy and energy efficiency the opportunity to compete fairly with traditional fossil resources. Now, I'm an environmental advocate, and it says so right on my business card, and it's a great time to be a clean energy advocate. When resources compete on a level playing field, time and time again, renewable energy and energy efficiency come out on top. In fact, Dominion Energy's IRP in Virginia this year concluded that solar energy is the least cost resource of any kind, including natural gas combined cycles. Clean energy is cheap energy, but you got to make sure that the policies are in place to achieve that. Allowing resources to compete fairly is key to reforming how utilities operate in South Carolina. And Mr. Benz has some very specific recommendations for how the Commission can do that. He also makes recommendations about securitization, which is basically refinancing the whole project. A way of taking whatever the Commission decides the ultimate cost recovery to be and lowering the net cost to ratepayers. Next, we'll present the testimony of Dr. Veradarajan, whose expert analysis analyzes different securitization scenarios and concludes it is a positive thing for the ratepayer with no adverse long-term impacts on the utility's well-being or its credit rating. Finally, we will present the testimony of Gregory M. Lander. If the Commission's goal is to protect ratepayers by ensuring that all resources compete fairly, That principle should apply not only on the supply side, but also when it comes to fueling. Interstate natural gas pipeline capacity projects are multi-decade, multi-billion-dollar investments. And they can be done with very little or very bad planning. This should ring some bells for people in South Carolina. The lack of planning can place ratepayers at great risk of paying more than they should for an asset that provides them little to no value. When the utility purchases that capacity from its own affiliate company, the risk is even greater. Dominion's operations in Virginia are a case study in this, and Mr. Lander has studied it in detail. He has combed through mountains of data, reviewed discovery responses, and listened to Dominion's own in-court admissions at the Virginia State Corporation Commission. And he will explain how Dominion has signed a contract with its own affiliate, Atlantic Coast Pipeline, without one ever studying whether it has a fuel resource need, without ever studying whether that pipeline capacity was the best kind of fueling resource to fill that unidentified need, and without ever studying whether that particular pipeline capacity was the least cost pipeline capacity available. That contract, as Mr. Lander will explain, will impose a net cost on Virginia ratepayers of between $2.5 and $3 billion, which Dominion has admitted at the State Corporation Commission it will charge its customers regardless of whether they ever use that pipeline. South Carolina has been through a lot in the last 10 years. We don't need to do this again. Let's make sure that we get a policy in place that prevents bad utility practices going forward. Now, clearly, this commission has no authority to regulate Dominion's operations in Virginia. That's not what I'm suggesting. But if the merger goes through, it will have the authority to regulate their operations here in South Carolina. And it does and should put in place a process where before you sign any contract, particularly a contract with your own affiliate, you prove that you need it and that it's the least cost option. That applies on the fuel and on the resource side. Again, our concern is the future of South Carolina. The internal utility process that brought us here today have failed South Carolinian customers. Moving forward, if we were to have a utility, we should have equally new practices. Practices that evaluate the costs of all resource options compared with the benefits, be they capacity benefits, energy benefits, fuel-saving benefits. We can get the process right going forward. The ratepayers will save money, and the utility will prosper. Thank you, and we look forward very much to participating in this proceeding.
Thank you. Okay, AARP.
Good morning. May it please the Commission, my name is John Kaufman, here on behalf of AARP, and it's 625,000 members here in South Carolina, many of whom are customers of SCE&G. Our goal here is to represent the best interest of all the residential households served by this utility. And we believe that those customers who have already been charged $2.2 billion as a result of this failed construction project deserve the best rate that you can arrive at here based on the facts, the law, and the Constitution. AARP generally opposes prepayment schemes similar to the Base Load Review Act, and the reason is that it takes the cost of service regulation balance and it tilts it. It shifts risk from the shareholders to the ratepayers. It forces the ratepayers to make the investment. We prefer to have the shareholders and the utility put their money at risk and then manage the investment themselves prudently. And if they can ultimately prove that it's used and useful, then they can have a reasonable and usually a quite generous profit on that investment. But they got to prove it first. And we find that when they use their own money, they tend to do a pretty good job. Of course, sadly here, we found that the BLRA money was not handled well. They did not act as good stewards of those ratepayer funds. We believe that the utility, based on the evidence that we have read in this case, was acting as if it was someone else's money. The concerns that AARP has have grown over the years that the BLRA was in effect. And we continue to raise questions about whether good money was being thrown after bad. Unfortunately, we did not feel that the BLRA procedures allowed us a full and fair opportunity to access the information in order to participate and challenge the prudency of this project as it was managed. So I want to thank you so much for having this proceeding, for involving the public in the way that you did. The 3 public input hearings were very appreciated. And also, we would like to thank ORS and their whole crack team for what they have done to piece together the evidence. They've done such a thorough job, and under the courageous leadership of Nanette Edwards, they have told the public the story, or at least we now know almost the entire story. And I want to thank the Commission for erring on the side of transparency and public information, and for removing confidential designations when they were not justified. So let me just talk a little bit about our legal position. We believe that even if you find that the old BLRA did allow pre-approval of the initial commencement of the construction project, it did not relieve the utility of the obligation to be prudent every day as they managed the project. We believe that they had a daily obligation to make sure that they were doing the most cost-effective thing and that they were looking at the big picture. And when the project was clearly not economic, to back off. We appreciate the ORS recommendation and their suggestion to cut off in 2015, but we actually think that the evidence justifies doing better for the consumer. We have an expert witness, Scott Rubin, who has 35 years of experience, and he has looked at a considerable amount of evidence, and he has come to the conclusion that in 2013, the evidence was compelling that this was not a prudent project. And so I hope that you will be here to hear his testimony on November 12th when he arrives. He has a recommendation that the BLRA charges all cease effective December 31st, 2018. And so, again, our position is that you go no further than the facts of this case allow as far as what rate goes into effect. We also think that you should continue with this approach of being very permissive with letting documents into the record, as well as being very transparent and removing confidential designations. If there is not a valid privilege and the document is a business record and it's legal, we don't see any reason to be hyper technical about applying the rules of evidence. We believe that you're a sophisticated trier of a fact. You can take the objections that the utilities have made into account in weighing the evidence. You don't need to exclude it or get caught up in highly technical evidentiary rules. So we support ORS on that. I'm just going to end right here, and I would like to conclude with a little video that is a 1-minute video from your local public hearing in North Charleston. If I can make it work, I hope you can hear it.
The fact of the matter is we have been duped, and we feel that we have been taken advantage of. Please look at what you are doing and what the implications are, particularly for those of us who are retired seniors. Retired seniors are home using utilities. Retired seniors are sometimes frail and need more heat or more air conditioning, pay more out of pocket for medical, who get low cost of living increases on our Social Security and our basic requirements. We are disproportionately affected by what you do and what the rates are for the utilities.
Okay. So I just wanted to show you that because sometimes these proceedings are so mired in complex minutia and so many lawyers in the room, sometimes we forget who's really impacted. So that was Ruth Rambo at North Charleston on October 15th, and I hope you keep her and people like her in your mind as you make your decision.
Thank you. South Carolina Energy Users Committee.
Chairman, I rely on my.
Thank you. South Carolina Attorney General. Mr. Elliott, I think that's the first time I've ever seen you turn down the microphone. So. No, don't try me.
Thank you, Mr. Chairman and members of the Commission. I'm Bob Cook from the Attorney General's office. And thank you to the Commission for allowing Attorney General Wilson to intervene on behalf of the citizens of South Carolina in this matter. We're here today for one purpose and one purpose only. That is to provide legal guidance to the Commission as it considers the constitutionality of the Baseload Review Act as applied to SCE&G ratepayers, and in its charge from the General Assembly to fix just and reasonable rates to take that into consideration as it moves forward. We're not here to help set rates. We are simply here to advise the Commission on these matters. As the Commission is aware, we issued an opinion back on September 26th of last year concluding that the BLRA is for various reasons constitutionally suspect because it denies ratepayers a hearing prior to increasing rates. It denies ratepayers the right to have its rates heard in the public interest, and it takes ratepayers' hard-earned money with them receiving nothing in return. So we intervened in this proceeding to assert that the opinion, and we filed an almost 100-page brief with the Commission asserting those arguments. The Commission may remember that Attorney General Wilson appeared here last December to present many of those arguments, and we reiterate those today. The situation is this. The more than 700,000 SCE&G customers deserve to have been treated fairly and constitutionally by the BLRA, and they were not. Instead, the BLRA turns out the lights and slams the door shut on ratepayers. In the meantime, we have asserted these same constitutional arguments in the various proceedings before Judge Hayes in Circuit Court, and we are hopeful that he will have a ruling shortly on the constitutionality of the BLRA. So we are here, simply put, to assert the constitutional rights of the customers so that they are not left holding the bag. We ask that this Commission consider these arguments as it moves forward to determine just and reasonable rates. That is my opening statement, and we, of course, submitted a pre-hearing brief to that same effect. Thank you very much.
Thank you very much. Okay, South Carolina Solar Business Alliance.
Hello, Mr. Chairman and members of the Commission. My name is Joe Dowdy, and along with Ben Snowden and Richard Witt, we represent the interveners South Carolina Solar Business Alliance, SCA. I'm sorry, I'll speak into the microphone a little better. My name is Joe Dowdy, and along with Ben Snowden and Richard Witt, we represent the intervener South Carolina Solar Business Alliance, or SBA, which is an intervener in Docket 2017-370E. We appreciate the opportunity to address the Commission today and to participate in these proceedings. The SBA prides itself on being the voice of the solar industry in South Carolina. It advocates for and supports favorable policies for solar power generation in this state, and its members include independent power producers, developers, construction contractors, and construction contractors of commercial, industrial, and retail solar photovoltaic generating facilities in this state. The SBA's member solar projects deliver clean, low-cost energy capacity to the grid. These projects insulate ratepayers from risks of construction cost overruns. I'm sorry.
Yeah, we just need to get you right in front of that mic.
I
so
apologize.
It'll
Trying to look
pick you
down
up
and see
a
if it
little
would help,
better.
but I apologize. Solar projects insulate ratepayers from risks of construction cost overruns, unexpected operating expenses, fuel cost increases, and volatility because the owners and developers of those projects bear those risks. The SBA has intervened in this proceeding to oppose the proposed merger unless the Commission imposes merger conditions that protect ratepayers from the potential adverse effects of monopoly control of electric generation by an investor-owned utility. And we understand that any combined entity will be a monopoly. But without proper controls, centralized monopoly control is antithetical to the free market principles at the heart of our economy. In the absence of competitive pressure created by an open market, utilities have an incentive and a fiduciary duty to their shareholders to build the biggest and most expensive power generating facilities they can get approved. And in the case of a utility self-build, the state's ratepayers typically bear the risk when things go wrong. That's the lesson of VC Summer. We submit that the remedy for this serious set of problems is a transparent and competitive market for energy production, one which permits ratepayers to benefit from production by independent power producers, including solar energy generating facilities when it's in the public interest. In interest of protecting ratepayers, the Commission should not allow the combined company to construct self-owned generation resources in the future without being required to go through a thorough, transparent, and inclusive planning process that's subject to this Commission's approval. Further, to avail ratepayers of the protections of an open market for production, there must be a fair and independently administered competitive procurement process that includes the purchase of energy and capacity from independent power producers, including solar producers. And we respectfully submit that without those conditions, there's simply too much risk to South Carolina's ratepayers. What we intend to show in this case is this. We're going to participate in this proceeding by conducting brief and appropriately coordinated cross-examinations. We respectfully submit that those will show that the factors and decision-making process that led to the VC Summer project were problematic, and there's a better process that is readily available. That there are significant costs and risks in developing a capital-intensive captive project like VC Summer, and there are better alternatives. The need for the combined entity's resource planning and procurement process must be consistent with the public interest and a fair and reasonable allocation of risks. That there's a need for the combined entity to use independently administered, competitive solicitations driven by Commission-approved integrated resource plans. That the combined entity needs to adopt reasonable plans, expectations, and processes for obtaining energy and capacity from independent power producers, including solar producers, in compliance with state and federal law. The combined entity needs to adopt reasonable plans for meeting capacity needs in the absence of the VC Summer unit, and that this Commission needs to consider the merging parties' expectations with regard to rate recovery and return on equity. We look forward to presenting these issues for the Commission's consideration and to assisting the Commission in its determination of the important public interest concerns raised in this docket. Thank you for your time this morning.
Thank you. Mr. Witt, Southern Current.
Chairman, Southern Current.
Thought that might be. I just wanted to make sure we got you. Thank you. South Carolina Public Service Authority.
Thank you, Mr. Chairman, members of the Commission. Most respectfully, as members of the Public Service Commission, you have the duty and responsibility to determine if the proposed merger is in the public interest. You have wide latitude to use your judgment to define the scope of the public interest. It is beyond doubt that the public interest impacts Santee Cooper and its customers and all citizens of South Carolina under these circumstances and in a controlling way. By statute, Santee Cooper is owned by the people of South Carolina. It exists solely for the benefit of the people of South Carolina. Indeed, SC Code Section 583180 mandates that Santee Cooper must act, quote, for the benefit of all the people of the state. And without question, the people are the public. Moreover, as confirmed by the South Carolina Supreme Court in Clark versus South Carolina Public Service Authority, the purposes for which Santee Cooper was created are expressly public purposes. Since the 1930s, when Santee Cooper was established to bring light to the darkest corners of South Carolina, Santee Cooper has provided safe, reliable, and low-cost power to the people of South Carolina. Through its wholesale and retail network, Santee Cooper supplies power to 2 million people in South Carolina. It provides power directly or indirectly to the people of South Carolina in all 46 counties of our state. Santee Cooper received legislative approval to become a joint owner with SCE&G in the VC Summer 2 and 3 project. SCE&G, the majority owner, took the lead on oversight of the project. In the course of this hearing, there will be ample finger-pointing and blame cast about. Yet these proceedings present an opportunity for this commission, an entity created to look out for the public interest and charged by law to protect the public interest, to in fact protect the public interest by protecting the people of South Carolina. This commission can protect that public interest by creating a public interest fund to assist those South Carolinians who are not SCE&G customers, but who have been adversely impacted by the developments that are the subject of this hearing. Santee Cooper proposes the creation of a public interest fund for the benefit of all those South Carolinians. This proposal seeks to have this commission act in its most fundamental way to protect the public interest of all South Carolinians. Indeed, the merger proposal itself seeks a finding that the merger is in the public interest of South Carolina and South Carolinians. Under the original proposed customer benefit plan submitted by SCE&G and Dominion, SCE&G customers are to receive $1.3 billion, representing 65% of the cost paid to date by SCE&G's customers. It is only fair and in accordance with the public interest that other members of the public who were proportionally impacted, that is, Santee Cooper customers, be equally ameliorated by your approval of the merger. Accordingly, Santee Cooper proposes that the same relief should be afforded to its wholesale and retail customers. 65% of the $540 million paid through 2017 by Santee Cooper customers, or $351 million, but not from SCE&G ratepayers. I repeat, but not from SCE&G ratepayers. These funds would be used for the benefit of Santee Cooper's wholesale and retail customers. These funds would be used to benefit the people of South Carolina, and this action would support a determination that the proposed merger is indeed in the public interest. Thank you very much for your attention.
Thank you. South Carolina Electric and Gas. We doing all E&G and Dominion together, or are we just doing South Carolina Electric and Gas? I just want to make sure where I'm right or wrong. Thank you.
Mr. Chairman, members of the Commission, I'm David Balser, King and Spalding, on behalf of SCE&G. SCE&G appreciates the opportunity in this proceeding to tell its side of the story for the first time. Let me begin by saying that SCE&G is very sorry for the impact that its decision to abandon construction of Units 2 and 3 is having upon our customers, the Commission, and the state. But no one disputes that abandonment is the right decision. Let's get 2 points out on the table right at the outset. First, if Westinghouse had not filed for bankruptcy, we would not be here today. And it is not SCE&G's fault that Westinghouse filed for bankruptcy. Second, even after Westinghouse filed for bankruptcy, had our partner, Santee Cooper, not quit the project, we would not be here today. And it is not SCE&G's fault that Santee Cooper quit. Once our contractor filed bankruptcy and our partner quit, the company had no choice but to abandon the project. The company is before this commission in these proceedings in an attempt to make things right for our customers and to do so in a way that does not destroy the company. In order to do that, SCANA and its subsidiary SCE&G have agreed to be acquired by Dominion Energy. The significance of that decision should not be overlooked by this commission. South Carolina's largest publicly traded company, a long-standing pillar of the business community, which employs more than 5,000 people in this state, is prepared to give up its independence and become part of Dominion in order to provide relief to customers. Why is SCANA willing to do that? Why is SCANA willing to sacrifice its independence? Because unlike SCE&G and SCANA, Dominion has the financial wherewithal to put billions of dollars of relief on the table for ratepayers, and it has done so. The Commission, I'm sure, is aware of the adage that success has many fathers, but failure is an orphan. If the project had been successful, there is no doubt that the ORS would be taking credit for its micromanagement of the project. But since the project failed, ORS is desperately trying to remove its fingerprints. As a matter of political expediency, ORS has concocted a false narrative that SCE&G concealed material information about the project from ORS and from the Commission. The evidence in this proceeding will show that ORS knew everything about this project. Every single ORS employee or consultant testifying in these proceedings has admitted that they knew, among other things, the many challenges that the owners faced in constructing the project, the poor productivity that plagued the project since the beginning, the incessant commercial disputes between the consortium members, Westinghouse and CB&I, the very real risk, particularly in 2015, that schedules and estimated costs of completion as provided by the consortium members would not hold, and the possibility in 2016 that despite Westinghouse's repeated and reasonable commitments to completing the project, Westinghouse would not complete construction under the fixed price option on the promised schedule. This information was not only disclosed and discussed with the ORS throughout the project over and over again, it was clearly and unambiguously disclosed to this commission in public testimony provided by SCE&G's executives. And as this hearing progresses, that testimony will be placed again before this commission as a reminder of what was said at the time, as opposed to the revisionist history that's being proffered now. For the past 10 years, ORS has stood shoulder to shoulder with SCE&G before this commission, supporting every single revised rate proposal submitted by the company. ORS filed multiple reports with this commission. ORS submitted thousands of pages of testimony to this commission. ORS reviewed every single proposed rate adjustment and after extensive diligence, each time determined that the rate increases were justified and that construction should continue. ORS had an office at the construction site. ORS had dedicated staff on site to oversee every aspect of this project. ORS participated in daily meetings with project managers at the site. ORS used extensive and intrusive document and information requests to exercise its oversight role. ORS's access to information regarding this project is unprecedented. Former executive director of ORS, Duke Scott, wrote several letters over the years to SCE&G expressing his state of, to use his words, heightened concern regarding the project. Further evidence that ORS was fully aware of the challenges that the project was facing. And we understand that Mr. Scott regularly shared these concerns with the Public Utility Review Committee and the governor's office. Interestingly, in discovery in this proceeding, we requested from ORS copies of the communications about the project with the governor's office, but ORS has refused to provide those documents. We believe that ORS is concealing those documents because they conclusively show that the ORS was fully aware of every aspect of the project and that the narrative that the ORS now asks this commission to accept is false. My friend, Mr. Richardson, in his opening statement on behalf of ORS, said that ORS wants the public to know everything. Well, I say to ORS, release those documents showing the communications with the governor's office. Let the public know what was being said at the time. ORS's false tale has two components. The first is that SCE&G misled ORS and this commission in 2015 by presenting an estimated completion based on Westinghouse's projected future rather than historical productivity factors. ORS's allegations are false. ORS was fully aware of the historical productivity factors and was fully aware that the estimated completion presented in 2015 used Westinghouse's projected performance factors rather than historical performance factors. And Steve Byrne and others in their testimony before this commission in 2015 made clear at the time that the consortium was not meeting those projected figures at the time. But, as Mr. Byrne explained, the company thought at the time that it was in the ratepayers' interests to adopt Westinghouse's proposed figures as opposed to the higher historical productivity factors that would have led to the imposition of higher costs at that time. Why put those costs on the backs of the ratepayers in 2015 rather than try to hold Westinghouse's feet to the fire to meet the efficiency standards that they had committed to? The ORS knew all of this at the time, and it settled the 2015 case. If ORS really thought that the company should have used the historical performance factors, as it now contends, why did it settle the 2015 case? The answer is ORS settled because it agreed that trying to hold Westinghouse to its commitment to improve productivity factors was a better course for the ratepayers than to use worse assumptions than Westinghouse was committing to. But now, failure is an orphan, and the ORS is trying to revise history. And I would note that the Commission issued an order in the 2015 proceedings expressly acknowledging the challenges to the project, including the challenges to achieving the projected productivity factors. The second part of ORS's false tale centers on the Bechtel assessment. The Commission will hear testimony from George Winnick, the construction litigator who retained Bechtel. Mr. Winnick has testified, in fact, Mr. Richardson deposed him for 8 hours in Atlanta not too long ago, that at the time Bechtel was hired, there were significant ongoing disputes between the owners and the consortium, and that litigation was anticipated. Mr. Winnick testified that he wanted to make sure that Westinghouse could not obtain Bechtel's work product in the event of litigation between the owners and Westinghouse. So Mr. Winnick, as is common practice when litigation is anticipated, retained Bechtel under the protection of the attorney-client privilege. Bechtel was asked to review the project and provide thoughts to Mr. Winnick it was not asked to review the project schedule. Every ORS witness testifying in these proceedings admits that they knew that Bechtel was involved in the project. ORS knew Bechtel was doing an assessment of the project. In fact, these witnesses observed Bechtel during the assessment, had back-channel communications regarding Bechtel, and had years' worth of opportunities to seek more information regarding Bechtel if they thought it was necessary to carry out the ORS's statutory oversight duty. Bechtel spent a handful of weeks evaluating the project, and you will hear Mr. Winnick testify that the report prepared by Bechtel was useless and that its rudimentary scheduling assessment was not worth the paper it was written on. Even Bechtel admits that its assessment was too preliminary, too perfunctory, too incomplete to justify any change to the baseline schedule that SC&G was relying upon and that SC&G had presented to this commission.
Mr. Balzer, I need for you to wrap up. So we've come past your time.
In conclusion, let me say this. Unfortunately, the ORS lacks the political courage to acknowledge that it knew about every aspect of this project. The commission now has the opportunity to save South Carolina from the finger-pointing, the scapegoating, and the revisionist history. And the commission can do that by deciding this case straight up on the merits. And on the merits, this case is not close. As Speaker Lucas recently noted in his letter to the ORS, the billions of dollars of relief offered by Dominion in the Customer Benefits Plan is clearly the best outcome for the citizens of South Carolina, and we ask that the commission adopt that plan.
Thank you. Dominion.
May it please the Commission, I'm Joe Reed on behalf of Dominion Energy. With this last word in the opening statements, I'm going to try to steer us in a little bit different direction. We've talked a lot about the past, but I want to talk about the future, as Mr. Cleveland referred to earlier. We can't turn back time and erase $5 billion of investment, but this Commission can and will change the future for SC&G, its customers, and the state of South Carolina. This Commission can choose among 5 different outcomes in this case, and I'm not going to spend a lot of time talking about SC&G's 2 backup plans. What I'd like to speak to are the 2 Dominion merger plans on the one hand and the ORS plan on the other hand. Approval of the merger and the original customer benefits plan, which I'll call Plan A, remains Dominion's preferred outcome here. Plan A gives an immediate shot in the arm to customers of $1.3 billion in upfront refunds and reduces customer bills by an average of 7%. It is a balanced and reasonable approach. But there's also Plan B, which has been developed as an alternative at the urging of various stakeholders to this proceeding, which is also an acceptable outcome. Plan B drills down on the permanent rate reductions. It limits the prudence determination in this case only to investments made on or before March 12 of 2015, as ORS insists. It will reduce customer bills by an average of 14% or more. It will bring the residential rate to within $2 of the temporary rate. It reduces a $5 billion problem to $6 on the bill. And it rolls back rates to 2009 levels, making them once again competitive. Now, under both plans, Dominion is bringing $2 billion in resources to the table. SCE&G cannot do that on its own, and nobody has proposed to make contributions and concessions of this magnitude. Dominion cannot reduce the NND obligation to 0, but this is a solution which is reasonable, rational, and superior to any other alternative, and one which promises security and certainty for customers and the state going forward. Now let's contrast that to the ORS plan, which suggests that the permanent rate can actually go significantly below the temporary rate. We can test that. Regardless, the ORS plan, if adopted, has these certain outcomes, and I will be direct. First, if the ORS plan is adopted, Dominion will not close the merger under those circumstances. Second, the ORS plan ignores multiple prior approvals of this commission and the plain language of the BLRA. It attempts to go further than policymakers have already determined would not likely pass constitutional muster, and it is undoubtedly going to be the subject of legal challenge on appeal. And third, the ORS plan will result in tremendous uncertainty as to the future of SC&G. That might include bankruptcy. That may include an inability to serve customers, as SC&G has in the past, a higher cost of capital, or another proposal for takeover that would be less favorable than the Dominion merger plan, which is on the table. The evidence will show, commissioners, that ORS is going for broke here, and they may end up with just that, a broken utility, or one which collects, in the end, more from customers after appeal than under the Dominion plan. Now, I don't pretend to ignore the enormous pressure that is on you all, as well as the ORS, in connection with this proceeding. Emotions are at a fever pitch, and their hit calls, we've heard them today, for heads to roll over the N&D project. This frustration is very understandable, and it will take courage and sober consideration to overcome it. Approving the merger in the Plan A or Plan B benefits plan is consistent with this Commission's mission statement to provide fair and reasonable outcomes through the regulatory process. It provides for certainty. It provides for significant relief from the N&D burden for SC&G's customers. It is a lawful result which puts the utility in the best possible position going forward to meet its public service obligations. It is not a perfect solution, but I would submit to you that we cannot let perfect be the enemy of the very good here. We look forward to presenting the evidence in this matter, to putting the N&D story to bed, and to a brighter future for SC&G and its customers through its combination with Dominion. Thank you.
Thank you. Okay, we've come to the end of opening statements. So we're going to take a break for lunch, and we'll be back at 1:30.